criminal case number 1214022323. The record should reflect that we are outside the presence of the jury. Counsel, will you state your appearances, please?
Chad Grunander, Sam Peed, and Jared Perkins for the state, Your Honor.
Randy Spencer, Your Honor, and Suzanne Gustin for Martin MacNeill.
Thank you. Did each of you receive the preliminary jury instructions approved by the court last night?
Yes, Judge.
Yes, Your Honor.
We talked about adding the witness credibility instruction. Does that meet with your approval?
It does, Your Honor, in the state.
Yes.
Thank you. Before the jury is seated this morning, are there any housekeeping matters to deal with?
Only if you wanted to deal with the tub mail that we discussed yesterday.
Have you had an opportunity to view the demonstrative exhibit?
I haven't seen the actual one, but I've seen pictures.
Do you intend to use it this morning?
No, we don't, Judge. No.
Okay. Why don't we deal with it later this afternoon? Very good. Could you bring the jury in, please? Counsel, has there been an amended information filed, or are we dealing with the initial information?
It's the original.
Thank you. Thank you. Please be seated. The court will call the matter of State of Utah versus Martin MacNeill. The record should reflect that the jury is seated. Good morning, ladies and gentlemen. Also that counsel are all present. Mr. MacNeill is present. By way of some explanation, now that you are sworn jurors, you are sworn to as triers of fact, to be judges of the facts. As a consequence of that, each time you enter the courtroom and leave the courtroom, everyone will stand. That's an explanation of why that happens, so that you're not surprised by it. As I mentioned, this is a criminal case. Trial is expected to last for 5 weeks. As we discussed last night, trial will generally begin at 8:30 in the morning. Again, let me express my thanks to you for being on time today. We will conclude at 3 o'clock. A lunch break will generally be held from approximately noon to 1 o'clock. We will also take periodic recesses to allow you to go to the restroom, stretch your legs, and to rest. I'm now going to read to you some preliminary instructions. A copy of these instructions is in your binder, if you'll follow along with me. It should be under a heading, Preliminary Jury Instructions, with a caption, State of Utah versus Martin Joseph MacNeill. If you'll turn to instruction number 1. Members of the jury, you have been selected and sworn as the jury in this case. The defendant is accused of committing one or more crimes. You will decide if the defendant is guilty or not guilty. I will give you some instructions now and some later. You are required to consider and follow all my instructions. Keep an open mind throughout the trial. At the end of the trial, you will discuss the evidence and reach a verdict. You took an oath to well and truly try the issues pending between the parties, and to render a true and just verdict. The oath is your promise to do your duty as a member of the jury. Be alert, pay attention, follow my instructions. Instruction number 2, plea and burden of proof. The prosecution has filed a document called an information that contains the charges against the defendant. The information is not evidence of anything. It is only a method of accusation or a method of accusing a defendant of a crime. The information will now be read. State of Utah versus Martin Joseph MacNeill. The State of Utah, by and through Chad E. Grunander, Deputy Utah County Attorney, charges the defendant with the commission of the following offenses. Count 1, murder, in violation of Utah Code Annotated Section 76-5-203, in that on or about April 11, 2007, in Utah County, the defendant did A, intentionally or knowingly cause the death of another, B, intending to cause serious bodily injury to another, commit an act clearly dangerous to human life that caused the death of another, or C, acting under circumstances evidencing a depraved indifference to human life, knowingly engaged in conduct which created a grave risk of death to another and thereby caused the death of another. Count 2, obstructing justice, in violation of Utah Code Annotated Section 76-8-306, subparagraph 1, in that on or about April 11, 2007, in Utah County, the defendant did, with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constituted a criminal offense, A, prevented by force, intimidation, or deception any person from performing any act that might aid in the discovery, apprehension, prosecution, conviction, or punishment of any person. B, altered, destroyed, concealed, or removed any item or other thing. C, made, presented, or used any item or thing known by the actor to be false. Or D, provided false information regarding a suspect, witness, the conduct constituting an offense, or any other material aspect of the investigation. And 2, the conduct which constituted a criminal offense would be either a capital felony or a first-degree felony. Ladies and gentlemen, the defendant has entered a plea of not guilty and denies committing these crimes. Every crime has component parts called elements. The prosecution must prove each element beyond a reasonable doubt. Until then, you must presume that the defendant is not guilty. The defendant does not have to prove anything. He does not have to testify, call witnesses, or present evidence. Instruction number 3, proof beyond a reasonable doubt. The prosecution has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is only necessary to prove that a fact is more likely true than not true. In criminal cases, the prosecution's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. Instruction number 4, presumption of innocence. Remember, the fact that the defendant is charged with a crime is not evidence of guilt. The law presumes that the defendant is not guilty of the crimes charged. This presumption persists unless the prosecution's evidence convinces you beyond a reasonable doubt that the defendant is guilty. Instruction number 5, role of judge, jury, and lawyers. All of us, judge, jury, and lawyers, are officers of the court and have different roles during the trial. As the judge, I will supervise the trial, decide legal issues, and instruct you on the law. As the jury, you must follow the laws as you weigh the evidence and decide the factual issues. Factual issues relate to what did or did not happen in this case. The lawyers will present evidence and try to persuade you to decide the case in one way or the other. Neither the lawyers nor I decide the case. That is your role. Do not be influenced by what you think our opinions might be. Make your decision based on the law given in my instructions and on the evidence presented in court. Instruction number 6, evidence. As jurors, you will decide whether the defendant is guilty or not guilty. You must base your decision only on the evidence. Evidence usually consists of the testimony and exhibits presented at trial. Testimony is what witnesses say under oath. Exhibits are things like documents, photographs, or other physical objects. The fact that the defendant has been accused of a crime and brought to trial is not evidence. What the lawyers say is not evidence. For example, their opening statements and closing arguments are not evidence. Instruction number 7, objections. Rules govern what evidence may be presented to you. On the basis of these rules, the lawyers may object to proposed evidence. If they do, I will rule in one of two ways. If I sustain the objection, the proposed evidence will not be allowed. If I overrule the objection, the evidence will be allowed. Do not evaluate the evidence on the basis of whether objections are made. Instruction number 8, order of the trial. I will now explain how the trial will unfold. The prosecution will give its opening statement. An opening statement gives an overview of the case from one point of view and summarizes what the lawyer thinks the evidence will show. Defense counsel may choose to make an opening statement right after the prosecutor, or wait until after all the prosecution's evidence has been presented, or not make one at all. You will then hear the prosecution's evidence. Evidence is usually presented by calling and questioning witnesses. What they say is called testimony. A witness is questioned first by the lawyer who called the witness and then by the opposing lawyer. After the lawyer finishes with their questions, you will have the opportunity to submit questions. In a moment, I will explain how to do this. Consider all the testimony, whether from direct or cross-examination, regardless of who calls the witness. After the prosecution has presented all its evidence, the defendant may present evidence, though the defendant has no duty to do so. If the defendant does present evidence, the prosecution may then present additional evidence. After both sides have presented all their evidence, I will give you final instructions on the law you must follow in reaching a verdict. You will then hear closing arguments from the lawyers. The prosecutor will speak first, followed by the defense counsel. Then the prosecutor speaks last, because the government has the burden of proof. Finally, you will deliberate in the jury room. You may take your notes with you. You will discuss the case and reach a verdict. Instruction number 9, conduct of jurors. From time to time, I will call a recess. It may be for a few minutes or longer. During recesses, do not talk about the case with anyone, not family, not friends, not even with each other. Until the trial is over, do not mingle or talk with the lawyers, parties, witnesses, or anyone else connected with the case. Court clerks or bailiffs can answer general questions, such as the length of breaks or the location of restrooms, but they cannot comment about the case or anyone involved. The goal is to avoid the impression that anyone is trying to influence you improperly. If people involved in the case seem to ignore you outside of court, they are just following this instruction. Until the trial is over, do not read or listen to any news reports about this case. Do not do any research or visit any locations related to this case. If you observe anything that seems to violate this instruction, report it immediately to a clerk or bailiff. Counsel, do you have an instruction number 10?
Yes, Judge. It's labeled instruction number 12-A.
My list goes from 9 to 12A. So are you missing 10 and 11 then?
We are.
Okay, let me pull those up. Ladies and gentlemen, do you have instructions 10 and 11? No? Okay. Maybe run 11, 12, 13 copies of that quickly. Counsel, for the record, the instructions are in the electronic record. They must not have copied. Could you distribute those to the jury, please? These aren't 3 hole punched. Maybe you can slip them into the pocket inside the binders. We'll get them punched for you, and oh, they are. Thank you. If you'll just insert them. You have one? Thank you. One extra. All right, do each of you have an instruction page? It should be numbered page 5 with instructions 10, 11, and 12 on it now. Yes. Very good. Instruction number 10, further admonition about electronic devices. Jurors have caused serious problems during trials by using computer and electronic communication technology. You may be tempted to use these devices to investigate the case or to share your thoughts about the trial with others. However, you must not use any of these electronic devices while you are serving as a juror. You violate your oath as a juror if you conduct your own investigations or communicate about this trial with others, and you may face serious consequences if you do. Let me be clear. Do not Google the parties, witnesses, issues, or counsel. Do not tweet or text about the trial. Do not use BlackBerries or iPhones to gather or send information on the case. Do not post updates about the trial on Facebook pages. Do not use Wikipedia or other internet information sources, etc. Even using something as seemingly innocent as Google Maps can result in a mistrial. Please understand that the rules of evidence and procedure have developed over hundreds of years in order to ensure the fair resolution of disputes. The fairness of the entire system depends on you reaching your decisions based on evidence presented to you in court and not on other sources of information. Post-trial investigations are common and can disclose these improper activities. If they are discovered, they will be brought to my attention and the entire case might have to be retried at substantial cost. Instruction number 11, note-taking. Feel free to take notes during the trial to help you remember the evidence, but do not let note-taking distract you. Your notes are not evidence and may be incomplete. On that issue, have each of you received a legal pad to take notes on? Very good. Instruction number 12, juror questions. During the trial, you may ask questions of the witnesses. However, to make sure the questions are legally appropriate, we will use the following procedure. After the lawyers have finished questioning each witness, I will ask if you have any questions. If you do, please do not ask the question out loud. Write it down and hand it to the bailiff. The bailiff will hand me your question. I will review it with the lawyers to make sure that it is legally permissible. If the question is appropriate, it will be addressed. If not, I will tell you. Instruction number 12A, witness credibility. In deciding this case, you will need to decide how believable each witness was. Use your judgment and common sense. Let me suggest a few things to think about as you weigh each witness's testimony. How good was the witness's opportunity to see, hear, or otherwise observe what the witness testified about? Does the witness have something to gain or lose from this case? Does the witness have any connection to the people involved in this case? Does the witness have any reason to lie or slant the testimony? Was the witness's testimony consistent over time? If not, is there a good reason for the inconsistency? If the witness was inconsistent, was it about something important or unimportant? How believable was the witness's testimony in light of other evidence presented at trial? How believable was the witness's testimony in light of human experience? Was there anything about the way the witness testified that made the testimony more or less believable? Has the witness been convicted of a felony? In deciding whether or not to believe a witness, you may also consider anything else you think is important. You do not have to believe everything that a witness said. You may believe part and disbelieve the rest. On the other hand, if you are convinced that a witness lied, you may disbelieve anything the witness said. In other words, you may believe all, part, or none of a witness's testimony. You may believe many witnesses against one or one against many. In deciding whether a witness testified truthfully, Remember that no one's memory is perfect. Anyone can make an honest mistake. Honest people may remember the same event differently. Mr. Grunander, is the state prepared to proceed?
We are, Judge, but may we approach just briefly for a moment?
You may.